Hello everyone, this is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. I have a few questions here from the community. I'll try to answer them as best as I can. Please remember, this does not create an attorney-client relationship, nor is this information guaranteed to be complete or accurate because there are so many little facts that can change answers to questions. This is not a substitute for a full-fledged consultation. That said, first question, can a company apply for my H-1B and green card together? I'm currently on STEM OPT. Can they apply for my green card while I'm still applying for H-1B? The answer is yes, absolutely. Remember that to file a green card, you don't even have to be employed by the company. It can be a future job. You can even be outside USA. So while the H-1B is going on, a green card can be applied. That is not an issue. But what could become an issue is what is the effect of the green card on OPT? What if your H-1B doesn't get selected? Does it have a deleterious impact? It becomes a little bit of a problem if you are not selected. But if you are on H-1B or you are sure to get an H-1B, for example, you've been selected and your case is pretty straightforward, I don't see any problem in applying for a green card even before the H-1B, green card simultaneously, or green card after H-1B. Next question. I'm on dependent visa, want to travel to India for 2 months. What if my port of entry in USA is different from the resident state? No problem at all. If you were an H-1B holder, I would think twice about it, but if you're a dependent, and let's say you have a cousin in New York, but your residence is California, you can come to New York. Or if you're getting a cheaper ticket to Delaware, but you live in California, no problem, you can come to Delaware. So I don't see that as an issue. Next question is, what percentage of asylum cases is approved? I have no idea. We do not process asylum cases. Our practice is very heavily focused on employment-based immigration, business-based immigration, and family-based immigration, especially complicated cases. My F1 expires in June 2020. I'm on my initial CPT. Can I travel after June without a new visa? Well, when you say F1 expires, I'm assuming what you mean is your visa expires. You cannot enter USA without a valid visa. And it is always risky to try to get a new visa while you are on OPT. Can my employer apply for my green card if I'm on F1? If yes, how it works? Well, the first part of this question was asked by somebody else. Can I apply for green card while I'm still on OPT? And the answer is yes, you can. But here is the problem. An H-1B is a dual intent visa. What does that mean? You are allowed to have the intention to file a green card even though you are on a non-immigrant visa. But F1 is not like that. If you have a green card pending and you travel outside USA, your entry on F1 can be denied. So with that in mind, if the time frames for travel are not a problem, you can apply for a green card while you're still on F1. Next question, can I use my OPT and STEM OPT once I graduate to do internship? You can do an internship on OPT but not on STEM OPT. STEM OPT has to be a paid employment, paid according to the prevailing wage standards in the area. Next question. If I am a manager now, can I move to EB1Q from EB2? The answer is maybe not. This question gets raised quite a bit. Remember, EB1C requires that you must have worked 1 year outside the USA for this group of companies for which you are working now for 1 year at least. So if you came in as on H-1B, let's say, and you got promoted to a manager, but you were never a manager outside, it is questionable whether you can go for EB1C. So generically, you cannot go for an EB1C unless you have 1 year of employment abroad with this group of companies. How long do I have to wait to apply for citizenship after getting married? That depends. If you are married to a US citizen, 3 years after you get your green card. If you are married to a green card holder, 5 years after you get your green card. Actually, you can apply for naturalization 90 days before the 5th year of your green card approval. I got my EAD approval 78 days ago, haven't received my EAD card. What to do? Well, obviously you need to contact the USCIS, go through the customer service, get them to track down the card. And if nothing else, you can apply for a duplicate card. And under the law, I think it's called the receipt rule. Yes, it's called the receipt rule. You can start working when you get the receipt for a replacement green EAD. You cannot do it with just the approval in the first instance, but if you have applied for a replacement EAD, you can start working with the receipt. My friend was sent back to India from Abu Dhabi immigration. He's on OPT extension. The officer canceled his visa. Is there any way to come back? He needs to talk with somebody and figure out what happened. Because even when they send you back, there are so many different ways they can send you back. For example, was he formally denied admission? That would make it so that he cannot return for 5 years. Okay. Next question, can multiple employers file or perm for green card? The answer is yes. As long as you have the good faith intention to join them, whichever green card comes first, and your multiple employers each has the intention to hire you in the future, you can have as many perm-based green cards going as you like. I wanted to know about the process of putting H1 on hold, moving to F1 and then coming back on H1. Is there any risk? No, people do it all the time, because what happens is, let's say you are a techie and then you got MBA admission into a good school and you don't want to miss that opportunity. You can go to F1, and while you're on F1, your H1 is quote unquote put on hold and you can resume once you're done. This year's H1 process has changed a lot. Can we have details for each steps? Well, it's really quite simple. It's not that complicated. On March 1st, we will start applying for registration, electronic registration. By March 21st, that will be over. USCIS will conduct a lottery on the registration. Beginning April 1st, we'll have 90 days to file the whole H-1B package. The advantage is employers are not going to have to put out money for us to prepare the whole package. So it becomes a lot cheaper, almost negligible amount of money for us to file for registration. The previous workflow was we had to prepare the whole package to be measured in the lottery system. Now we just have to fill out basic information. And so this is a good process if they do it right. If they screw it up because of electronic glitches and computer glitches, then of course it's no good. But I think overall this is a step in the right direction for the employers and the employees. F1 status is complete, applied for reinstatement, have approved I-130 but unable to file for adjustment of status. Well, I-130 is not going to help you. I'm not sure what you're asking me. The I-130 becomes useful only when you are close to filing adjustment of status. But if your priority dates are not current, having an I-130 is not going to help you. You can hope for reinstatement. That's the only thing you're hoping for in the immediate future. Next question. New H-1 change of status approved with old I-94. Do we need to report the new I-94? Well, look, as long as your I-94 is valid for the duration of the approval, I don't see any reason for you to worry about. There's nothing to report. But if your I-94 is not approved for the whole duration of your H-1B approval, talk to your lawyers. Next question. We want to file a visitor visa for my husband's parents. Husband is on H-1B, moved to Dallas. Parents are working. Kindly explain the visa process. Well, there is really nothing special about the process for your parents, for your husband's parents. It's the same like the rest of the world. They will fill out the requisite forms at the US consulate. They will arrange for an interview. In the interview, they can be asked questions about their son. They should carry some evidence that he's maintaining status, such as his pay stubs, etc., copies. They may not be asked anything, but that's the process. There's nothing special that I can think of. Next question. I have a query regarding my parents' visa. My father retired from his job last year. So in his DS 160, you selected retired option. That's the right option. Ask for previous experience, and we could only enter 2 experiences. That's okay. Is this enough to show? Yeah, if you only can enter 2.5 years, look, if the forms are restricted, there's not much you can do about it. Okay, so don't worry about it. I don't think this is a major issue. Next question. I applied for my EAD recently and I got a message confirming that my application is in process. We are relocating. Well, you have to file. You should do 2 things. If you are changing locations while any application is pending, file for AR11 online. AR11, just Google AR11. You can do it online. This is change of address. Everyone, even green card holders, must file a change of address form within 10 days of moving. Second thing you do is you contact the USCIS customer service and inform them that your address need to be updated. So do both AR11 as well as informing the USCIS. Regarding J1 extension, what are the possibilities? Well, it depends upon the program. Is it possible to get sponsor for hospitality industry? A lot of people in the hospitality industry, as far as I know, are going through third parties. Remember, J1 visas cannot be issued by an employer directly unless they happen to be something like a large institution or they happen to be a school or a college or a hospital. Typically, J1s are issued through third party sources. I have my passport renew issued. This is an incomplete question. My company is looking for a law firm who can help in H1B filing. Of course, we'll be happy to assist, but if you want a lawyer locally, I don't know where you are located. We have clients in all 50 states. You're welcome to reach out to us. My email is help@immigration.com. Anyone recently went to Canada for the first time H1B stamping? Can you please share your experience? Is it safe to go for first time H1B visa stamping? Look, this is a question to be asked of the community, but as a lawyer, I can tell you this: avoid travel if you can. The safest H1Bs are for those people who are working in-house rather than at client sites. If you are working for a client at a client site, you could be delayed for many months. Next question: is it a good idea to ask my employer to apply for both H1B and green card? Sure. Apply for green card as quickly as you can. Further up, in the beginning, I have discussed this issue in detail. Is it worth waiting for your green card for 12 years and citizenship for 5 years after approximately, or migrate to Canada to get your citizenship in 5 years? It depends upon where you want to live. Is it worth it? That's a personal decision. That's really not a legal decision. I cannot tell you what is good for you. The reason I like the current system of laws compared to what we had a few years ago is that now, after your green card is started, PERM is approved, I-140 is approved, and 180 days the I-140 stays approved, you can keep moving jobs. You carry your priority date, you carry your right to extend H1 through any employer, so you become fairly safe within a couple of years. Therefore, I don't mind the 12 years wait personally, because I like the United States. I like the way things work here. But it's a personal decision. I can't really help you there. I arrived here in Michigan 1 month before with my wife. I'm on J2. Want to apply for EAD. Somebody suggested me not to apply for EAD. I think it's okay. I don't think the 90-day rule is an impediment here because it's an allowed activity under J2. So I personally don't think it's a problem. Next question, H1B question. If a candidate got through H1B through a consulting, working for a third party client location, wants to switch, what role does the previous employer play? They cannot really interfere with your H1B filing. If you have a contract with them of some kind, talk to a local lawyer in the state where the contract is to be, under whose laws the contract is to be followed. But under immigration law, old employer can't do much. Can we switch without letting them know? Yes, you can. Note, candidate is on STEM OPT. You still can. I don't think there is any problem, but I can't comment about the contract parts. Normally, remember this, and if you go to our website immigration.com and see some of my articles, I have written on the issue of contracts that try to restrict people who are on H-1B. There are some very heavy rules against the employer who wants to restrict people. Okay? How to find out whether USCIS is doing premium processing for H-1B this year or not? Nothing. You cannot really find that out until we get closer to the time, which is April or so. So we won't know till then. How do I extend my J1 visa? I just discussed that in another context. It depends upon the kind of J1 visa you have. You need to ask your program sponsor. I'm looking for an immigration lawyer to apply for O1, artist, for actor and director. If you can recommend lawyers, we can assist. We do O1s. If you need to reach out to me, feel free to send out an inquiry to help@immigration.com. That's my email. Looking for a good immigration lawyer in Washington State. I don't have any recommendation in Washington State, but we do have clients in all 50 states. Feel free to drop your question out to us. My email is help@immigration.com. I wanted to know how long it takes for a green card holder to bring their spouse to USA. First thing you need to do is check the visa bulletin. It depends upon the country of birth. So right now, even India-born people are current. So technically, it should just take about a year, year and a half. Looking for immigration lawyer who can deal with I-751. We can. You can reach out to us at help@immigration.com. I-751 is removal of conditional residence. Normally, if you are living with your spouse, it's relatively easy to get that processed. Converting C1 to B1, I have no idea. I have not dealt with, these are crew members. I have not dealt with C visa cases. I know there are some restrictions on how you can convert status. Sorry, I don't know the answer off the top of my head. What is the procedure from changing non-immigrant visa to immigrant visa? Well, that's a very lengthy question. You're basically asking me about pretty much 1/3 of immigration law. So it depends upon whether you're applying through family-based, asylum-based, or employment-based visa. Green card can come in 3 or 4 flavors. So difficult to answer that question. Next question is, I have pending I-751. I came on 28th August 2015, gave me 2 years temporary green card. Immigration gave 1 year green card to me. This is 3 times. I have no idea what you're talking about. If you explain that question further, because normally what happens is, when you come on a marriage-based green card, you will get a green card for less than 2 years if your marriage is less than 2 years old. After that, you will apply for removal of condition using I-751. So I really don't know what you're asking me. Please explain that question more. I'll try to answer it. Parents arrived in USA on Feb 2015. When can I apply for their citizenship? They have been in India in this year's. Again, your question is very vague. I'm sorry, I don't understand what you're asking me. Parents have to wait 5 years, like everybody else, to apply for naturalization. They must have been in the US at least 2.5 years, and none of their stay outside USA should be more than 6 months. 6 months or less. If it is 1 year or more, they lose their green card also. Those are the general rules. Need to go to India for 2 years, green card is in process. Is it easy to get H-1B and come back? Yes, of course. As long as you have the right kind of job, I don't see any problem with that. Last question. If green card gets cancelled, and is it possible to get green card if we reapply after getting visa for second time and coming? Look, a cancellation of green card, unless it is for some kind of a fraud, is not a restriction of any kind from applying again. So yes, you can apply again unless the green card cancellation was based upon some kind of fraud. That said, folks, it's great to be able to answer these questions. I hope to have a more interactive session the next time. That's what we are planning to do in this community. We'll see you all once again. This is Rajiv S. Khanna from immigration.com signing off.